Morning, everyone, and I hope that everyone can hear me. And a big welcome to today's webinar from Tees in conjunction with SFB HR Consultants. We're really pleased to have so many of you joining us for today's webinar, which is all about the future of employment law and what employers and organisations really need to know now, but also looking to the future into 2026 and beyond. And lots going on. We will get into that and what we're going to talk about in a moment, but just a bit more about us first as today's hosts. We are from Tees, me, Rob Whittaker. I'm the head of our business law team. We've got 16 of us in the team. We've got a team of over getting on for 400 staff at Tees now across 6 offices, covering the broad range of legal services that you could require, including more recently joiners dealing with things like intellectual property and regulatory breach and all those areas that you as businesses and organisations may want help from us on. I'm also joined today with my co-host Ola McGee, who is joining us as an associate in employment law with me, advising on employment law matters for both employers and, dare I say, employees. So we get both sides of that coin. And really pleased to introduce Michelle Brinklow from SFB HR Consultants. We work very routinely with Michelle, and I will invite Michelle just in a moment to talk just a bit about SFB. But before we get to that, last but not least, Georgie Pittman, who has been instrumental and key in helping us get our slides and content together today. Give everyone a wave, Georgie, before we take you off screen. But Georgie will be keeping an eye on questions. If we have time for questions today, which hopefully we will, Georgie will be collating questions. And then if we have time, we'll be asking us as the panelists at the end any key questions. I should also add that no one else can see your questions. If you have questions that you would like us to answer privately, you can either put them in the chat or indeed you can email us direct after the event. And I should also add that I'm sure that some of you may want to take notes as you go along, which is absolutely fine, of course, but just for your reassurance, we will be distributing the slides as meeting notes, and a copy of the recording will follow after today's event. So I will briefly hand over to Ola and Michelle to say hi, wave and mention themselves, and then we will press on from there.
Are you going
Michelle.
first, Ola, or shall I?
I'll
Thank you.
Hi. Hello, everybody. Welcome to our webinar. I'm Ola McGee, and I, as Rob said, work with him in the business team, predominantly focusing on employment law. So welcome. Michelle?
Thank you. Hi, my name's Michelle Brinklow. My company is SFB Consulting. We're an HR consultancy company based in Bishop Stortford. We have clients all over the UK, and welcome.
Thanks, Michelle. Thanks, Ola. If we can now press on to the next slide, please, Georgie, and gives people the content that we'll be covering today. As I will mention in a moment, this is a time of incredible change and challenges in employment law and for organisations and employers generally. And I'll give some rationale for why in a moment. We are not planning to eat the whole cake today, okay? But today is part of a program of content that we are rolling out because we know our clients and contacts are craving that content about what now and the future means for employers. So today we'll be focusing on some key concepts, which is the Employment Rights Bill and in particular day one rights, one of the key elements of that levelling up, if you like, that has been so heralded by the government. Then Ola will be talking about sexual harassment and changes in the law around sexual harassment and what that means for your obligations as an employer. And then we'll be talking about navigating challenging economic conditions, because we know that with the increase in national insurance and other factors, which I'll mention in a moment, these are challenging times. Now, you may think, well, what's Michelle going to talk about then? But Michelle is key and essential here, because while Ola and I inform and hopefully not bore you with the legal content, Michelle will be able to provide some really insightful practical tips on each section. So please keep an ear and eye out for those, because we rehearsed this yesterday and they are key and really, really valuable and helpful. And I think even when we were going through this yesterday, we all found something useful. So hopefully you will too. So future of employment law. Why are we talking about all this stuff? Next slide, please, Georgie. Some facts and figures, and hopefully very nicely presented to illustrate what you face. 28 changes in employment law just with the Employment Rights Bill alone. So we're talking about one of the most significant periods of employment law change in years, probably over a decade. Okay, probably for me the most striking change since the statutory dispute resolution procedures before they were abolished, and we'll touch upon that theme in a bit more detail later on. 32% increase in employment tribunal single claims, and we are certainly seeing many more tribunal claims coming through, and we are seeing many more tribunal claims stall, so that you will see a claim issued but not heard for 12, 18 months, possibly more. 21.8% of people reporting sexual harassment for the year ending March 2024 said this took place at their place of work. You would think, I'm sure, as today's audience, how could this happen in this day and age? But as Ola would explain, it does. And there are particular and important legal ramifications and reasons to get it right and mitigate your risk. And then, of course, we have the climate, we have the national insurance increase, we have the minimum wage increase, we have the GDP estimated to have shown no growth in July 2025, following growth of just 0.4% in June and a fall of 0.1% in May. I'm sure that many of you are feeling that, and I won't dwell on that. But what we hope to do today is to provide you with information to help you navigate these challenges and mitigate the risk, and dare I say it, focus on the job at hand and try to keep the distractions of speculative or real claims to a minimum as far as possible. And that's what we're trying to do today, to keep that positive concept and approach in mind. So if we can move to the next slide, please, Georgie. Again, we said it's not just the Employment Rights Bill. We won't be talking about these points in detail today, but there are other changes to keep in mind, and these are but some of them, okay? So there are changes to the minimum duration of apprenticeships under the Apprenticeships Miscellaneous Provisions England Amendment Regulations. I think Georgie's picked really long legislation for me to talk about today. There's the Victim and Prisoners Act 2024, which makes void any provision in a settlement agreement that precludes the making of protected disclosure. Now that sounds serious, and it is, but keep in mind that it has been the case already that any provision that seeks to prevent you being a whistleblower or reporting a criminal offence will not be enforceable. But this legislation really ramps that up and reinforces the fact that you've got to be really careful to ensure your settlement agreements, if you use them, are up to date, particularly around things like confidentiality. That's something, of course, we can help with if you need help with that. And then we have changes to privacy rights and obligations. This is a sort of piece of legislation that kind of crept up, I would say, but amongst other things, it changes how we might deal with a subject access request. And again, to my mind, if you don't know about it and it comes across your desk in terms of subject access requests made, please do seek advice, because that sort of thing is valuable to be aware of. I've glanced through that because, as I say, we've got quite a lot of content to get through today, but please do come back to us with questions on any of these points. So, moving swiftly on, Georgie, the Employment Rights Bill. If we can move to the next slide. Employment Rights Bill at a glance. I was told yesterday when I read these all out that I sounded really dull, so I will simply focus on those that we are going to talk about today, which is unfair dismissal day one rights, which you can see highlighted, sexual harassment, which Ola will talk about, and collective redundancy and limits on fire and rehire following the dismissal of 800 piano workers and the ramifications that followed from that. But please keep in mind that list when you get slides through. Have a read through, because these changes are all changes that are looming and are important to keep in mind. Statutory sick pay being one example, where there will be a day one right and unlikely to be a requirement to meet the lower earnings limit to be qualified. So lots of stuff in there to think about. We'll be focusing on these topics today, but we'll be covering the other topics in future webinars, seminars, the podcast that Michelle and Ola are driving, and also articles and social media content. Keep an eye out. We'll be delighted to share our knowledge with you. Next slide, please, Georgie. Thank you. timetable for implementation and what we're looking at today. So again, that's there really as an aid memoir for you for today, and we'll come through in the notes. But those that I'd really focus on today are those changes in October 26 and 27, and in particular around fire and rehire, also the tightening of tipping law and employers taking all reasonable steps to prevent sexual harassment, which Oliver will talk about, and the day one right for unfair dismissal, which I'll now move on to. Next slide, please, Georgie. Thank you. So this was much publicised. Day one right to claim unfair dismissal and removing the requirement to have 2 years service to claim ordinary unfair dismissal. Now, as practitioners in employment law, and which is also mentioned in a lot of commentary that's out there at the moment, which echoes our experience, when an employee has less than 2 years service, some of you I'm sure will be aware that employees and their advisors may seek to circumvent or get round that 2-year qualifying requirement. And the way that they will seek to circumvent or get round that 2-year requirement is by asserting claims for things like unlawful discrimination in breach of the Equality Act, and or that they were a whistleblower, which doesn't require any service and indeed applies pre-employment, and so on. And therefore, the argument goes that, in fact, introducing this as a day one right not only is the right thing to do, but the argument goes that it should reduce the number of speculative claims based on spurious or cynically submitted allegations. Not all, but some. I have to say, it remains to be seen whether that will happen. From our experience, if you've got a claimant who is determined to pursue a complaint, given that there's nothing to deter them from doing so in terms of an upfront fee, it will not be uncommon to receive a claim that has the whole kitchen sink thrown in, and we remain to see if this will reduce the number of claims based on discrimination or otherwise. How does this work, and how will that removal of day one, removal of the 2-year qualifying period work? Well, that is buried, and this is where it gets a bit dry just for a moment. That requirement is buried in section 108 of the Employment Rights Act 1996. And the intention under the Employment Rights Bill is to remove that requirement altogether. So the requirement to have any length of service would be removed, with a small tweak, which is that they will then be inserted a new exciting section 108A, which will say that these rights won't apply before the employment has commenced. And of course, that might seem a very subtle point today, but if you have issues with a candidate before they've started in future, once these new rules come into play, that could suddenly become very relevant and important to keep in mind. So we could see a rise in ET claims as a result, but it remains to be seen. And keep in mind that certain claims, such as discrimination and under the whistleblowing legislation, wouldn't even require you to have started the job in the first place. We then have how will this work? And this initial or probationary period of employment, which is mentioned in the slide there. And I'll talk a bit about that, I think, now to explain a bit from where we have presented on this when those bill terms first came through, and we know a bit more now, I think, to be able to talk in more informed terms. So the idea is that this initial period will be a period of, if you like, light touch for most potentially fair reasons to dismiss, with a process which is effectively a sort of streamlined process to dismiss. I say for most reasons to dismiss. It will cover the potentially fair reasons of conduct, capability, illegality, some other substantial reason. It will not, for the avoidance of doubt, cover redundancy so far as we are aware, which again is important. The reason it will not cover redundancy, we are told, is that redundancy is a business reason for dismissal, whereas the other reasons relate to the individual and go to the crux of having flexibility through that first 9 months to part company with someone if it just ain't working out, bluntly. Okay, all right, and that's key to keep in mind as these new rules come into place. It's also important to keep in mind that these new rules will apply to dismissals using this light touch approach, which take effect so that the dismissal is within the first 9 months. We think it's going to be 9 months, but can include up to 3 months notice. So what does that mean? That means that the light touch approach could in effect apply to dismissals which take effect within that first year of employment. Okay, and that's where we seem to get to with that. What does the light touch approach include? We don't yet know, but we do know that it's going to require a meeting. We do know that it's likely to be a meeting where you have a right to be accompanied in the way that you would in relation to a formal statutory meeting under the ACAS code. We're not told if it should be in writing, but for the reasons that Michelle and Ola will talk about through themes today, I'm sure you'll understand that for us as your lawyers, we are always keen to ensure that there's an evidential trail. And we are told by the government that this will not be a return to the really very difficult to navigate statutory dispute resolution procedures for those of you who are of a heritage to remember those, old enough to remember those. We know that they created all sorts of unintended consequences with unfair dismissal findings on process alone. We are told that will not happen, but again, watch this space. What does that mean for us? It means making every hire count, and it means making sure we follow the due process. And Michelle will give you some really good insight into making every hire count in a moment. We think it's going to affect how recruitment is approached, but for now I'm going to talk about when things don't work out and those potentially fair reasons. If we can move to the next slide, please, Georgie. So the reason for dismissal to be potentially fair needs to be, as I think I mentioned, capability, the person is not up to the job, conduct, but needs to be confined to what the employee is doing in their work. See the case of Singh and London Country Buses, a 1976 case. Redundancy, illegality, the person can no longer lawfully do their job. An obvious example could be if you are required to hold an enhanced DBS certificate to undertake your work and no longer hold that certificate for whatever reason, and some other substantial reason, which is the catch-up. And that includes a reorganisation that does not give rise to a redundancy, or could include where it just ain't working out through a clash of personalities. Now, in terms of those day one rights, we think a light touch will apply, but even so, one of these reasons will need to be valid. And of course, as we talked about earlier, to guard against those speculative discrimination claims, you need to make sure that you have not just valid reasons, but evidence-backed reasons that you can stand by, and that where possible, you have followed a due process. That process will vary and will not be one size fits all. It will vary from one organisation to the next, which again, Michelle will talk about in a moment, and it will vary dependent on the issue. Is it that the person can't do the job they've been employed to do? Could they change that with some training, support, guidance? Is it conduct? Do they have the wrong attitude? Are they committing misconduct? Is there simply not enough work to go around? Redundancy, which Ola will talk about in a moment. Is it illegality, or is it some other substantial reason? But in each case, make sure that you follow the right process and document it. Consistency, communication, early intervention, themes that we will talk about over and over again, but are key to guarding against those speculative claims. Next slide, please, Georgie. And the importance of due process. Now, keep in mind, whilst we don't know what will happen in that first year, that first period, we do know that we have the ACAS code in practice already. That's already in place. We do know that a failure to follow the ACAS code can not only be relevant to liability, a finding against you, but also result in up to a 25% increase in compensation payable. And we do know that this is something that the tribunal will look at as a key starting point for if there's been a fair process. And you might have the best reason in the world to dismiss, but if you haven't followed the process, it's likely that you'll have an adverse finding. And it's also likely, or more likely, that you'll have a disgruntled employee who goes off to see a solicitor who tries their luck, or indeed has a valid claim. Internal policies and procedures. Follow these and follow these consistently. Again, a theme that we will repeat and make no apology for repeating today, because it's really key and important to keep that concept in mind. The tribunal would expect you, including in cases of misconduct, to consider alternatives to dismissal. One that commonly comes up for us is in relation to some other substantial reason. It's not uncommon for our clients to say that their customer has said they don't want this individual working for them anymore for whatever reason. It would be risky and risk a claim to make a knee-jerk reaction to say that means we're going to dismiss this person. There should be consideration of whether the client can be persuaded as to why, and to talk through that, and whether there's another solution. Alternative roles within the business should be considered, and so on. Are there mitigating circumstances? Is there a disability? Have reasonable adjustments been made? All of these things to keep in mind and document that you've kept in mind. And crucially, is dismissal within the range of reasonable responses? If it is not, then it's likely that the dismissal pursuant to section 98(4) will be considered unfair. And keep in mind recent cases, including Knightley in 2022, failure to provide a right of appeal can be relevant and determinative in there being an unfair dismissal, and by contrast, dealing with the matter on an appeal well can rescue an otherwise unfair dismissal in the right circumstances. Now, I'm sure that you've all had enough of listening to me for a moment, so I am going to duly mute myself in a moment and hand over to Michelle for some really good tips on how to navigate these issues.
Thank you very much, Rob. So I think firstly, it's really, really important to start with policies and just make sure that all the policies are updated. But having a policy on the shelf just collecting dust is not going to do the job. So make sure that you follow the policy, and just because you have a policy in place doesn't mean that you're covered. So please make sure that the policies are reflective of your organisation. One does not fit all. And as we've been discussing, soon that 2-year safety net is going to disappear. So it's more than ever important to really get to know the policies and make sure that they're in line with the ACAS code as a minimum. So just putting that to one side for a moment. Now, recruitment is really important to make sure we get that person in place, the right person. And I always think that interviewing alone is quite a risky strategy now. So some people perform really, really well under interview conditions, and others less so. So I think you have to be a bit more creative in these areas and maybe consider other avenues, including testing and things like that. So hopefully we do get that right person in place, and now we have to make sure that we use that probationary period to guide and support. In order to assess progress, we need to have regular progress meetings, ensure that you're picking up any performance issues early on. It's costly and time-consuming recruiting new staff, so use that time to shape that employee, train, guide them, support them, and really give that person your full attention during those first weeks and months. I can't stress enough how important it is to just go that extra mile during the probation. But anyway, moving on. There is always going to be times when you have to deal with that staff member through the disciplinary process. So make sure that all of those who are involved in the process are suitably trained. There are lots of elements that go into a disciplinary. And it's really important that you get it right. So tribunals love paperwork, and I always say the investigation is the most important part of the process. So whether it's a simple warning for lateness or attendance, for example, you have to carry out an appropriate investigation, followed by a disciplinary by somebody who wasn't previously involved. So make sure that there's evidence, witness statements, could involve CCTV footage, referring to policies and processes. And of course, employees have certain statutory rights. So like throughout the process, and make sure that you do get advice and support from your HR or legal. And I think a final thing to bear in mind is consistency. Treat everybody the same. Make sure you have reasons for your decisions. Warnings are issued, consistency for the level of offence. It's very common for someone to complain that, let's say they were dismissed, they appeal, and then they allege that others were just issued warnings or not dealt with at all. So something to bear in mind.
So we're now going to move on to talking about preventing sexual harassment in the workplace, and this is a key topic that is coming up increasingly with the changes in the law. I will therefore, without further ado, hand over to Ola to take us through all that's involved.
Thanks, Rob. So unless you've been operating in a bubble, you'll be aware that the law changed in October last year, and it's now created more of a positive duty on employers to prevent sexual harassment in the workplace. We've seen quite a few high-profile cases in the press, and it's no real surprise that since the advent of the Me Too movement that these changes to the law have been somewhat inevitable. Moving to the next slide, please, Georgie. So what is sexual harassment? Well, it's defined as unwanted conduct of a sexual nature that has the effect of violating a person's dignity or creating an intimidated, hostile, degrading, humiliated or offensive environment. As Rob mentioned earlier, unfortunately, sexual harassment in the workplace is an everyday occurrence in spite of the law. In fact, some recent surveys from Unite the Union in the UK show a significant prevalence of workplace sexual harassment. The most recent survey from this year finding that a quarter of women experienced sexual assault and 56% were recipients of sexually offensive jokes. There's also very low reporting rates, with only 15% of women and LGBTQ workers who are disproportionately affected reporting incidents of sexual harassment, such as unwelcome jokes and unwanted touching, to serious assault. In my view, the aim of the new Act is to create cultural and societal change around tackling sexual violence against women. And it provides a framework really to establish clear standards and expectations for both individuals and employers. Next slide, please, Georgie. So this is the Act. It's the Worker Protection Act 2023. It's one of the most significant recent shifts in employment law, and so obviously worth understanding what it actually does. Sexual harassment is already prohibited in the workplace. The new duty sits alongside the existing obligations under the Equality Act. It doesn't create an independent cause of action for employees to pursue an employment tribunal. Instead, allegations of a breach of this duty can only be considered by a tribunal where an employee's claim for sexual harassment has already been upheld. It therefore introduces a proactive duty on employers to prevent harassment, and a big shift from the reactive prevention that has been in place beforehand. This means that it's no longer enough to deal with complaints after they happen. Employers have now what I can only describe as a general anticipatory duty, requiring them to identify and address risks of harassment from all sources. So again, a major change from the previous reactive prevention, taking what the Act calls reasonable steps to prevent sexual harassment. I suppose you could say that the aim of the Act is to address the issues faced by victims in the workplace around speaking up or being supported. And this, again, it essentially provides a framework to establish those clear standards and expectations. Next slide, please, Georgie. Like all good statutes, unfortunately, the Act is silent on what reasonable steps actually entails. There have been no specific examples provided to help employers mitigate claims under this legislation. But we do think that there are some common principles that can be applied to assist with explaining what this can mean for you. So when we talk about the new proactive duty to prevent harassment, the key question is always, what does it actually really practice? The reality is there is no single checklist. It depends on your workplace, your size, and your risks. But employment tribunals are going to expect to see some certain foundations in place. So let's break this down. First, leadership has to come from the top. If your senior team aren't modelling respectful behaviour, there's no policy in the world that's going to protect you. Culture flows downwards, and leaders need to set the tone by demonstrating the behaviours they expect. Importantly, please don't wait for the first complaint before acting. You need to be proactive. Second, we need clear policies. As Michelle mentioned earlier, it's no use having a dusty document sitting on the internet, on your shelf, whatever. Policies need to be clear, accessible, regularly updated, and consistently applied. And when I say consistently, I mean no exceptions for senior people, no brushing things under the carpet. You need to revisit these documents and steps regularly in every situation where a complaint is raised. This is to ensure ongoing relevance and address trends and emerging issues, because nothing stays still, nothing remains the same, as we've seen by employment law. Third, training. I think this is one of the most effective tools. It's not just a one-off tick box exercise. You need regular refreshers. It should cover what harassment looks like, including things like microaggressions, inappropriate banter, and online conduct. Increasingly, employers are also training on bystander intervention. We've seen quite a bit of this, giving their staff the confidence to step in early, as well as conflict management, so that managers can diffuse situations before they escalate. Fourth, we need to have open conversations, create some safe spaces where people feel comfortable asking questions and raising their concerns. I think you find that the earlier employees speak up, the less likely problems are to escalate into formal disputes. There also needs to be a clear owner, someone senior, whether this is HR or management. They should be visibly responsible for compliance with the preventative duty, so that when an employment tribunal asks who's in charge of this, you need a name rather than a dunno. And then finally, we've got the risk assessments. Michelle will go into detail about this later on, in a bit more detail. But what I will say is that not every part of your business faces the same risks. A sales team out networking are going to face very different challenges to a back office team. So identifying those hotspots allows you to target your training and monitoring where it matters most. So pull all of that together, and you're not just reducing legal risk, but you're creating a safer and more respectful and ultimately more productive workplace. And that is clearly the real goal. So can we move on to the next slide, please, Georgie? So what happens if an employer fails to meet this new preventative duty? The first and perhaps most immediate risk is enforcement action from the Equality and Human Rights Commission. The HRC has been given real teeth under this legislation, and they've already signalled that they'll be taking a very keen interest in how employers respond. Their enforcement powers are wide-ranging, and they can investigate potential breaches, issue notices requiring employers to prepare an action plan. And this isn't just a paper exercise, but a practical plan to remedy breaches and prevent future issues. The HRC can also require legally binding agreements where the business commits to take specific steps to tackle harassment. And in the most serious cases, they can also seek injunctions to stop unlawful practices. So we're not just talking about reputational embarrassment here. This is regulatory intervention with potentially very public consequences. And on top of that, obviously, there's the tribunal risk, where an employee wins a sexual harassment claim. The tribunal must now consider whether the employer did comply with its preventative duty. And if it finds that you failed, it can order compensation uplift of up to 25% on top of whatever damages the employee has already been awarded. So you'll remember that, or you'll know, if you don't, compensation for discrimination and harassment claims is uncapped. So that means in a serious case, especially one involving multiple employees or long-term harm, that 25% uplift could add tens of thousands of pounds to your liability. So the message is this: failure to meet the preventative duty exposes employers on 3 fronts: regulatory enforcement, reputational damage, which Michelle will go into, and significantly higher tribunal awards. So it's not just that taking these reasonable steps is a legal obligation, it's essential risk management in my view. Next slide, please, Georgie. So the cost of it when it goes wrong, I won't go into very much detail about the Vento guidelines because I will assume that most of you know about these, but the tribunal don't just decide if harassment happened, they also decide how much compensation is appropriate, and that's when these Vento guidelines come in. And they're the 3 bands: the low band for less serious cases, the middle band for more serious or ongoing incidents. A good example of this is the case of Frick and Vical of 2022, where it was found that sexual harassment had taken place over a significant period, and the tribunal awarded the claimant £17,000, which is smack bang in the middle of the middle band. And then you've got the upper band, which is reserved for the most serious cases, often involving sustained harassment or a toxic culture. There was a case, another 2022 case, where the claimant resigned as a result of a misogynistic culture, and the award there was £35,000. So nothing to be sniffed at. I think on top of these bands, the tribunal, you'll be aware, can also award aggravated damages. And this is where the employer's behaviour was malicious, particularly high-handed or oppressive, and that's where costs can really escalate. So what I will say is prevention is better than cure, and to bring that to life, Michelle will share some practical steps that employers can take now to reduce risk and build a safer workplace.
Thank you, Ola. So this is all about cultivating a safe environment. So not just in terms of risk of harassment, but also by ensuring staff feel safe to report allegations and they don't just suffer quietly until the final straw happens. This must come from the top. So senior management must have buy-in and filter down throughout the organisation, no matter the size of the organisation. So again, we start with good, robust policies, a clear anti-harassment policy, a complaints mechanism. And again, I have to stress that they need to be policies that are followed to the letter and that everyone knows about. It's no good having these policies that no one knows about. So training is a must. Now, just put that must in capital letters and underline it twice. From day one, every member of staff should be trained on what's expected, what is and isn't acceptable. That's from entry level roles to senior management. So I would suggest add this to your induction program, then continue on a regular basis. It must be continuous education for everyone. Your company has to mitigate the risk of harassment. We must show that we have given clear guidance on what is and isn't acceptable. I feel like I'm saying must a lot. So we need to establish a zero tolerance policy. As an employer, you have a duty to protect staff from all forms of harassment, even when the harasser isn't part of your company. So that, yeah, third-party harassment is back again, by the way, if you hadn't noticed. It wasn't that long ago that it was repealed. So not only should you review your own policies and employee contracts, but also look at contractor agreements, supplier contracts, and the like. We need to create an open dialogue about these issues, encouraging staff to share their experiences, ensure we deal with grievances promptly. You may also consider having a main point of contact for all harassment complaints. if you drag your feet in dealing with grievances, you will be seen as condoning the behaviour and you weaken your position. So we also need to conduct risk assessments. Identifying these potential risks will allow us to implement preventative measures, reducing that risk. Where staff have to, say, meet clients alone or travel abroad, or they may face power imbalances within the workplace, we have to bear this in mind and carry out assessments. We also need to think of solutions like maybe some kind of buddy system or something, so staff don't feel uncomfortable in certain situations. Also, when traveling abroad, it may be that you have to educate staff about local customs and norms in those countries. I think these measures will go some way to ensure incidents are reported, encourage open communication, and make sure that you carry out regular reviews. Dealing proactively will show that you're serious and will go some way to avoid reputational damage as well. So I'm not allowed to mention the C word, I've been told, but in case you don't know what I'm referring to, it's that time of year where the big man with the presents comes down the chimney. Be very mindful of work events, whether inside or outside of the workplace, as you as a company are responsible for their safety, and to ensure, so make sure that you remind people of those policies, have clear guidelines, what's expected, what isn't, carry out risk assessments, so that staff are able to have fun whilst feeling safe. I feel like the fun police at the moment. And just to finish, I'm going to advise you of a giveaway. Woohoo! So if anyone would like a complimentary zero tolerance to harassment poster, either get in contact or add a note to the webinar. I think there's a notes or a chat bit, and we'll happily send one across to you. And I'm handing back to someone. And next slide.
Hi. Thanks, Michelle. So before we wrap up harassment, it's just important to flag what's coming next. The Employment Rights Bill, which is obviously progressing through Parliament now, is set to significantly expand the preventative duty. And rather than just taking reasonable steps, employers will need to take all reasonable steps to prevent harassment. Obviously a higher band, and will demand more robust systems, training and monitoring. The bill will also make employers liable for one-off third-party harassment, as Michelle said. So, for example, inappropriate behaviour by a customer, client or contractor. And it won't be limited just to sexual harassment, but it would be any form of unlawful harassment which could give rise to that liability, even if the employer didn't know about it in advance. Finally, the time limit for bringing a harassment claim will be extended from 3 to 6 months. So that will give employees more opportunity to bring claims, and therefore extending the risk to employers. These reforms won't come into force until 2026, but obviously the preventative duty already exists today. So the direction of travel is clear. Employers will need to be proactive, assess risks and take visible action to prevent any harassment happening before it happens. And now we move on to the next slide, please, Georgie. And Rob, am I handing over to you?
You are indeed. Ola and Michelle, thank you so far for all of that really useful content. Key content, I'm sure everyone will agree, and those key messages of preventative steps and getting your house in order with policies and procedure and everything else that goes with that they've talked about. Please do put that in hand now while there's the opportunity to do so. So we'll move on, and there's only one slide on this, and it is again a much publicised part of the Employment Rights Bill to end fire and rehire, although we've got a deliberate question mark there, because if I read you the statement from the Department for Business and Trade, the government wants to end unscrupulous fire and rehire tactics that leave working people at the mercy of bullying threats. And to that, we would say quite right too. But they go on to say that businesses must be able to restructure to remain viable, to preserve their workforce, and when there is genuinely no alternative. And I'll explain what that means in a moment. The extent to which it applies to your business, I can't speak for every business or organisation that's on today's call, but I can say that on the limited data that's available, it's thought that the use of fire and rehire in the way that is being targeted and restricted is probably limited to less than 1% of businesses in the UK at this time. So we're not talking about something which is generally going to impact businesses or could impact businesses in a once in a business lifetime occurrence. But for that, it's worth keeping this in mind. These rules follow, as I mentioned earlier, the much publicised activities of P&O, who dismissed without consultation in the region of 800 workers. And there were some specifics to that situation which are not relevant to today's general discussion. But the upshot of it was that last year, a code of practice was brought into force, failure to comply with which could result in a 25%, that magic figure again, uplift in compensation payable in certain circumstances. And this is the requirement under that code that employers take all reasonable steps, again, those common phrases, to explore alternatives to dismissal and engage in meaningful consultation with a view to reaching an agreed outcome with employees and their reps. The code also goes on to say that employers should not raise the prospect of dismissal, if you like, as a bullying threat when it's not actually envisaged to get an outcome that the employer is seeking. The new rules will go further than that. And again, these are not yet enforced, but are well worth keeping in mind. It will be automatically unfair to fire and rehire unless the organisation can demonstrate those very narrow circumstances that can apply, meeting all of these criteria. And I'll read these from the government guidance. Evidence of financial difficulties affecting or likely to affect their viability, i.e., the business will go down the pan unless the actions are taken. Changes are there to eliminate, prevent, significantly reduce, or significantly mitigate the effect of those financial difficulties. And the need to make the contractual changes is unavoidable. We're talking about situations where businesses have no choice in order to survive but to implement these changes. Those very narrow, once in a business lifetime, one would hope, events, as opposed to using this as a mechanism to have a different contractual regime. Okay. Now, keep in mind that that relates to fire and rehire. Keep in mind that businesses routinely vary contracts of employments, whether by agreement with staff members, whether as part of a change in the role, that could be a promotion, that could be all sorts of scenarios. This is not what this legislation is aimed at. You would go back to the basic principles that you can agree changes with your employees in the normal course of discussions, or you may have flexibility or variation clauses in your contracts, which where they apply to the variation or change that you want to make, where your contract allows you to make the change, may be permitted too. So where do we want to think about now? Now's to think about what clauses do you have in your contracts? Now's to think about, do we have the right people in the right roles? And we've positioned this slide now rather than dealing with the earlier changes under the Employment Rights Bill, because it seems to us that this quite neatly then leads into our next section, which is all around the challenging circumstances of business reorganisation and where businesses may need to make redundancies, on which I will now hand over to Ola. And the next slide, please, Georgie. Thank you.
Thanks, Rob. So yeah, as Rob said, fire and rehire is one way that employers have tried to force change, but in many situations, the real issue isn't just about changing terms, it's about whether the roles themselves are still needed. The stakes are even higher in redundancies because we're talking about people potentially losing their jobs altogether. Redundancy is, I'm sure you'll know, one of the hardest conversations any employer or manager will ever have. It affects people's livelihoods, their families, and their sense of security. And understandably, emotions run high. So the law is evolving here too. employers are going to face a wider definition of what counts as a redundancy. There'll be stricter requirements for meaningful consultation and much closer scrutiny of whether there has been a fair selection process is applied and followed. So let's look at what's changing in redundancy law and what employers now need to be doing differently to stay compliant and protect themselves in a way that's both legally robust and respectful to all of the people involved. Next slide, please, Georgie. So we'll start with the basics and what redundancy is actually in the law, and this is the legal definition here. Basically, redundancy arises in three main scenarios. A business shuts down completely, a particular workplace shuts down, or there's a reduced need for employee to do work of a particular kind. What it isn't is a shortcut to deal with performance issues or conduct issues. And using redundancy as a cover for something else is a fast track to tribunal trouble. Also, you'll need to remember that employees will not automatically accept what you reason with them at face value, and tribunals will look at the real reason and whether the real reason for dismissal fits within that redundancy definition. Next slide, please, Georgie. One of the biggest risks now with the changes that are coming up are come with collective redundancy. So as I mentioned earlier, the definition is getting wider. Under the Employment Rights Bill, the rules on collective redundancy are being expanded. This means that dismissals across different sites may now all count towards the threshold of 20 redundancies in 90 days. So you can't silo or sites or departments to avoid triggering collective consultation obligations. If you're proposing to make 20 or more redundancies within that 90-day period, you have a legal duty to consult collectively with employee reps or a recognised union. The key point here is consultation must be early, meaningful and genuine. If you've already made your decision before the consultation, that's not a consultation at all. And if you fail to consult properly, the tribunals currently can award up to 90 days pay per effective employee. So that's a massive liability. Next slide, please, Georgie. Other than consultation needing to be meaningful, both collectively and individually, of course, the employer will need to and be required to define clearly which roles are redundant. So it's not just about the individuals, it's about roles. And it's something that I really try and push home to my clients. If the business no longer needs a particular role, that is a redundancy situation. But if you've lost confidence in someone's abilities to do their job, that's not a redundancy, and tribunals will see through that quite quickly. You'll need a fair and transparent selection matrix. If you're reducing headcount within a group, you'll need objective criteria, so things like skills, qualifications and performance. But even with that, applying that, you'll need to watch out for indirect discrimination, not least because attendance scores might disadvantage disabled employees, flexibility criteria might disadvantage parents. So your selection matrix must be transparent and equality proof. You're also expected to consider alternatives to dismissal, so redeployment, retraining or adjusting hours before confirming redundancy. This duty continues right up to the final day of employment. So if a suitable vacancy opens during the notice period and you don't offer it, that could then make the dismissal unfair. And finally, protected characteristics must always be considered. Tribunals will scrutinise whether age, disability, pregnancy or another protected trait was indirectly affected by the process. You'll need to equality proof your redundancy decisions. And if you don't, you'll be at serious risk of discrimination claims. The key takeaway from all of this is that obviously redundancy can be lawful and fair, but you need to follow a process that's transparent, consultative and sensitive to equality law. And this is where recent case law really sharpens the point. Next slide, please, Georgie. In the Haycock's case, the tribunal criticised the employer for consulting too late after the decisions had effectively been made. The Court of Appeal stressed that consultation has to be meaningful and at a stage when employees can still influence the outcome. That means no secret scoring exercises behind the scenes, no fait accompli. Employees should be able to see the scores, challenge them, and have their voices heard before any decision is confirmed. It's a two-way process, the consultation process. It's not just about asking whether someone wants alternative work. It's about inviting ideas that might avoid redundancies altogether. And as Rob mentioned earlier with the unfair dismissal, don't forget appeals. A well-run appeal process can actually correct earlier mistakes and save you from an unfair dismissal finding. Next slide, please, Georgie. Failing to get consultation right doesn't just slow things down, it can expose employers to real financial and legal consequences. So looking at what's at stake here, we've got the protective award. If you fail to properly inform and consult during the collective redundancy, the tribunal can award up to 90 days pay per effective employee, as I said earlier. Under the Employment Rights Bill, that cap may be doubled to 180 days. That's a massive, serious financial risk. And so for larger redundancy exercises, the liability could be eye-watering. Second, it makes it harder for employers to ignore these obligations. In the past, I think that some businesses took the view, well, I've seen it certainly in my experience, that the protective award was a risk worth taking. Doubling the penalty changes that calculation. So it's because it's a much more punitive regime designed to force compliance. Third, employers need to keep an eye on the trigger point. The rules are triggered when 20 or more redundancies are proposed within a 90-day period. But under the new framework, dismissals across multiple sites may be aggregated. So that means that employers can't treat each site in isolation. You'll need to monitor numbers across the business carefully to avoid inadvertently falling into non-compliance. So the message is clear. Consultation is not optional, and the costs of getting it wrong are about to get much higher. So before pressing ahead with a redundancy, employers will need to really pause and test their reasoning. My advice is in each case that I prefer a prepared business rationale, business case, to actually go through the steps that you feel that you need to take and to test it. HR and legal input is obviously essential because these processes are technical and sensitive, and a misstep could cost thousands, tens of thousands in employment tribunal awards. And that's the perfect moment to hand over to Michelle, who's going to talk through the practical steps businesses can take now to get ahead of the reforms and manage these risks effectively. Michelle?
Thank you very much, Ola. So we always tend to ask so many questions when a client comes to us to ask about redundancies. Often we're told that someone's not performing, so we want to make them redundant. That is not a redundancy situation. Performance management processes take time, but it's imperative that we deal with them through the performance management process, not redundancy. So once we're clear that the redundancy reason fits the definition, the key thing is consultation, as Ola said. Giving information as early as possible, you're never going to be criticised for giving too much consultation. The company has to be able to show that other considerations have been considered. For example, it may be a freeze on recruitment, cut back on travel costs, flexible work arrangements, maybe cross-training employees. It must be meaningful. Whether you're consulting with employee reps, trade union reps, or individually, the idea here is to look for ways to avoid the redundancy, but it is a two-way process. So it's not just for you to look for other roles within the business, for example, and just for you to look for ways to avoid, but it's for that member of staff to also think of ways that they feel may avoid their redundancy. So, for example, they may suggest a change in hours, taking on other responsibilities, or something like that. You have to consider it. It's really important that you don't just say it's a blanket no to all suggestions. It's crucial to have a transparent process, so early communication, as I keep saying, as early as possible. If you have to put together a selection criteria, so if you have a pool of employees within a team, let's say, and you need to reduce the number within that team, then you need to figure out a fair, transparent criteria that doesn't discriminate against any of the protected groups. For example, people with disabilities or those on maternity or recently returned, and just note that returning mothers have extended protection. So it's very common to use sickness absence as a criteria, as Ola mentioned. Be mindful that this could inadvertently discriminate against someone with a disability because they're more likely to have higher sickness absence rates. So it's always wise to take advice before creating the selection criteria, but also once scored, another pair of eyes to take a look at it. So take your time with the process, don't rush, be fair, be transparent, because it's not just the people at risk that are affected, but also those who are left behind. It's much easier to get things back on track once you've gone through a redundancy process, when those left behind feel that you've been fair. And again, it can be a complex process, so it's important to take advice from HR or legal. Next slide, please, Georgie. Okay, so just as a wrap up from my side, just make sure that you're reviewing contracts, handbooks, policies. Make sure that all staff responsible for carrying out processes like disciplinary, grievances, redundancies are trained and don't skip parts of the process. Be thorough. They're quite technical. Grievance procedures are not carried out. Grievance procedures need to be carried out proactively. Don't drag your feet, because as I said previously, it could look like you're condoning the behaviour. And please keep in touch with us. Let us keep you informed on all the upcoming changes. There is a lot. And if you feel you need an HR audit or want to talk through something, then you can contact one of us. And just to repeat, offer alert. If anyone would like the zero tolerance to harassment poster, get in contact.
And as we head towards the close soon but not yet of today's presentation, this is, as we said, but one part of all of the things that employers should be considering. The Horizon Watch also includes flexible working codification, with day one rights becoming standard and employers increasingly under obligations to be able to explain themselves as to why a flexible working request is declined. TUPE reform is in consideration. Watch this space, and future content will roll out from us once we know more on that, but keep that under consideration, particularly if you work in a sector with lots of outsourcing, insourcing, or providing service work to third parties, particularly in that sector. Ongoing focus on menopause, policy integration, and algorithmic fairness in HR decisions. And AI use in hiring. These will all be increasingly under scrutiny and legislative scope, and inclusive workplace practices and socio-economic bias being considered. Now, we will then, I think we have got time, Georgie, if we move to the next slide on the case law roundup, some of the cases that we touched upon today and ongoing cases to keep in mind, I would just recap on now. And then we think, have some time for a few questions too, which will be fantastic. So cases we've talked about today and which you will receive in your pack to keep in mind. We have Women's Scotland versus the Scottish Ministers, which is the Supreme Court decision that the words sex, woman and man mean biological sex. We've not dealt with that today, but that has been obviously a key and much publicised case to keep under consideration, and there is guidance that has followed that. That guidance, I have to say, has been subject in itself to some scrutiny and criticism. Again, keep these considerations under your eyes and keep in mind. I talked earlier around unfair dismissal. I talked earlier around how to navigate that, and Michelle talked about the importance of policies, procedures, due process. And a really good example of that to mention is the recent case of Houston versus Ofsted. Mr. Houston was found unfairly dismissed. He was an Ofsted inspector. He brushed rainwater off a year 8 child or student and was dismissed for misconduct. But in that case, there was no clear no-touch policy. There was no prior guidance. There was no training. And the tribunal found therefore, or I should say on appeal, it was found therefore, that the dismissal was unfair. Having those policies in place, ensuring that everyone knows what the expectations are for behaviour, will be really relevant to your business and should be cultivated and crafted to suit your business, to be best suited to address issues that arise. Haycox and ADP is the redundancy case that Ola mentioned. There's more notes on that in the pack should you need it, but this is this point that redundancy consultation must begin at an early formative stage. It must give the employees, those affected, every chance to, with the employer, engage in a meaningful consultation to seek to reduce, minimise, avoid compulsory redundancies. It must be procedurally fair in all circumstances, or you risk a finding against you. Joe Phoenix and the Open University, again, an interesting, presently very topical case, one to be aware of, which will affect some of these organisations and others less so, but is still worth keeping in mind. When it was found that a university professor was discriminated against and harassed by her employer, the Open University, because of her gender critical beliefs. And she also, I think, in that claim, succeeded in her claim for constructive dismissal. And then we have the ongoing case, which it's likely that we'll report on further in future content, because that case is, as far as I'm aware, not yet concluded, which involved a nurse who was suspended after confronting a transgender doctor in a hospital changing room. Again, this has been widely reported in the news. We won't mention it anymore today, other than to say this is what's being reported. We're keeping a close eye on the outcome of that case and how it may affect businesses, organisations, employers, employees. So we really do hope that you have found today useful and that it's covered some of the content that's relevant to your organisation. We are very mindful that every organisation has its own circumstances, challenges, requirements, and no one business will be the same as the next. But some key themes that you would have heard from us today are around the importance of consistency of approach, fairness, having the policies in place, having the procedures in place, not letting them gather dust on the side, keeping mindful and aware of the legal changes, and reaching out for help when you need to, and living the values that you promote at your organization. And although there's been some warnings today, although there's been some, this is what happens when it goes wrong, our intention, and which we hope has come across, is that in our content now and in future content that we share with you, to give you as organizations and HR professionals the opportunity to have informed communications with your staff and to mitigate and minimize the risk of distraction, so you can really focus on getting good work done by an engaged workforce that enjoy working with you. And that's never going to always be the same and never going to be easy, but hopefully providing you with this information empowers you a bit on that. I won't say any more today, bar questions, and Georgie will now rejoin and share with us any questions that we can answer in the time permitted.
I've got a question here for Ola. How do we avoid discrimination when using a selection matrix?
You have to be fair. You have to apply well, good judgment. I think that in all cases, you need to look at whether there are any factors that disproportionately affect certain groups of people. So, for example, let's say, for the sake of for this question, you have a mother who works on a part-time basis because she has primary care for her children. That person cannot be, one of the selection criteria would be somebody that doesn't work. So they would be choosing somebody that doesn't work on a full-time basis. You wouldn't be able to use that particular factor as a reason not to select that person for redundancy. The criteria would need to be more objective and not focus on that particular reason. So, you know, it really depends on the situation and the protected characteristic involved. But in all situations like this, I think the key is to obtain advice early. We assist with these selection matrices all the time and provide input into those decisions. Well, not the ultimate decision, but the criteria that you can potentially apply and the shortfalls of certain criteria compared to others. Yeah, I think it really depends on the situation, and obtain legal advice before.
Yeah. I think a really good answer there from Ola, really specific and helpful. I think also, Ola, you touched upon a couple of key points there, which are around you mentioned objective criteria. I think we'd agree, all of us on today's call, that where you can apply objective rather than subject, i.e. rather than opinion-based criteria, you tend to be in much safer ground. And of course, it avoids the risk of an employee who is at risk saying, well, that's just your opinion, I have a different view. So where you can, appreciate that's not all the answer, but where you can point to more objective criteria, you'll be better placed in fending off challenges.
We've got one here for Michelle.
Yay.
If a member of staff tells me that they're being harassed in confidence but doesn't want to take it further, what should I do?
It's a tricky one. So under the Equality Act, you have a legal duty to prevent harassment in the workplace. So even if the effective employee doesn't want to pursue it, you can't ignore it. You have a duty to, once you're aware, you're obligated to take reasonable steps to protect the employee, but not only the employee, but protect other employees within the organization. And if you fail to act and the harassment continues, then you'll find yourself liable.
Would you say, Michelle, also that it's really important that there's a good evidential trail? You mentioned this earlier, that you've looked into allegations, including to protect anybody in the future and not just the individual in question, so that you can ensure that you've put in place safeguards?
Exactly, yeah.
And we've got one more question for Rob. What if we haven't followed process but have good reasons to dismiss?
Okay, yeah, no, that's a good. So I think if my understanding of the question is correct, is we've got one of those potentially fair reasons to dismiss, but we haven't followed the process. Going forward, it will depend on whether you're in that first period of the initial or probationary period, where a light touch process would be required. And we don't yet know what the implications are if it's not followed, but it's also likely that compensation would be potentially capped at a lower level for failure to follow due process during the initial period. Outside of that initial period, or where the initial period doesn't apply, if you fail to follow due process but you've got a valid reason, you're immediately on the back foot. You're immediately facing an adverse finding in the tribunal. But there is a key case, it's now a fairly historic case, but still relevant, of Polkey and AE Dayton Services. And what that case says, amongst many other things, and summarizing today, is that if you can demonstrate that the right decision was reached by the wrong process, that can help you to reduce the value, if you like, the amount of compensation payable. Now, that's subject to some caveats. That ain't going to help if you are found to have discriminated. It certainly isn't going to help if you, using some of the content from Ola and Michelle, have used, say, redundancy as a convenient title or option where in fact it's an underperforming employee. But if you have, for instance, selected someone for redundancy and it was the right person to go, but the process wasn't right, it can help in reducing the amount of compensation that's payable. But it's the sort of thing where you really need to get some advice, because, as I say, you're already back on your foot. You're already facing liability findings if the process hasn't been followed. Hence the gist of today, which is get the process right, and you're already one step ahead. But a good question, Georgie. I think probably that brings matters to conclusion. This is part of a program of information and communication and updates that we're carrying out across the forthcoming year through to June, July next year and beyond. And we'd be really interested to hear from you as to topics you want covered, how you want them covered, whether you prefer face-to-face, which we like, whether you prefer webinars. Please follow Michelle and Ola's podcasts, which are great fun and cover topics in a shorter but still informative way. Please follow our content on social. Keep feeding back to us, letting us know what you want to hear from us on and what matters to you, because what matters to you matters to us. Thank you again for listening.